more modern. We got it right. Natural rights don't matter. Our wisdom, our intellect, our arrogance of a government and the governing body has more import, has more value, has more to do with what we do today than the wisdom of those unalienable rights and the Constitution that came out of it. You realize that in the Constitution, for every time it gives us a responsibility, it says 4 or 5 times what we can't do. Because the framers were interested in knowing the condition of men that we would abandon. Our tendency would be to allow the concentration of power to abandon those very principles that they put into the Constitution. What did Madison have to say? Just on the general welfare clause of the Constitution. He anticipated the Elena Kagans of this world. He said, with respect to the words general welfare, I've always regarded them as qualified by the detail of powers connected with them. To take them in a literal and unlimited sense would be a metamorphosis of the Constitution into a character which there is a host of proofs was not contemplated by its creators. You see, that's how we've gotten in trouble as a country. That's why our economic future is not secure, is because both the Congress has exceeded its authority under a limited Constitution, and the courts have failed to rein us in. They have failed to recognize their obligation. So we're going to have someone who believes that the precedent and the wisdom of modern men is much more important than the original intent of our founders to keep us free, to secure our liberty, to provide our unalienable rights to pursuit of life, liberty, and the pursuit of happiness. Well, where's another area? If you read the Constitution and you read where they have set up our judicial system, and what they reference as they say that is that the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. They gave no wiggle room for the utilization of foreign law in interpreting the U.S. Constitution. None. And here's Elena Kagan. It may be proper for judges to consider foreign law sources in ruling on constitutional questions. Here's what the Constitution says. Here's what the nominee to the Supreme Court says. Exactly opposite of what the Constitution says. In other words, it's okay to use any source of law you want, not the source that the Constitution says you will be bound by in your oath. Let's take it a step further. Same quote. Judges can get good ideas on how to approach legal issues from a decision of a foreign court. It may be proper for judges to consider foreign law sources in ruling on constitutional questions. Here's their oath. I do solemnly swear that I will faithfully and impartially discharge and perform all the duties incumbent upon me as a justice under the Constitution and laws of the United States, so help me God. Under the laws and the Constitution of the United States. That isn't foreign law. That's the U.S. Constitution and our statutes. So as soon as she takes the oath, her very philosophy violates it because she honestly testified that it's fine to use foreign law to interpret our laws and our Constitution. Again, how do we get in the trouble that we're in today? How do we get that 20 years from now, every man, woman, and child in this country is going to be responsible for over $1 million worth of debt? How do we get to the point where $350 billion of waste, fraud, and duplication occurs every year in the federal government? How do we get to the point that we can take people's rights away because we so deem so in the Congress, in our smart modern wisdom that lessens liberty and freedom throughout this land? We do it because we don't use the book and we don't follow the oath that we are sworn to uphold. And that's the U.S. Constitution and the laws of this land. And then it comes to the Commerce Clause. Elena Kagan. The Commerce Clause has been interpreted broadly. It's been interpreted to apply to anything that would substantially affect interstate commerce. When asked if a federal law requiring Americans to eat 3 fruits and 3 vegetables every day would be unconstitutional, Mrs. Kagan avoided the question, simply saying that would be a dumb law. But Madison had something else different to say. Ambition must be made to counteract ambition. He's talking about us. If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. We've had this vast expansion since the late 40s in this country in the Commerce Clause. And it started with Wickard versus Fillmore. A farmer raising chickens was raising his own wheat. But the government didn't want him raising his own wheat because they had a lot of limits during the 30s, the Great Depression. Limits what you could grow. So he owns his own land, he has his own chickens, but the Supreme Court says you can't raise your own feed. You got to buy it from somebody. So here we started with the Supreme Court ruling and moving in to take away the freedom of an individual farmer to raise his own feed for his own chickens for a greater good, supposedly to control the price and availability of wheat. What's happened to us since then? Look at the expansion of the Commerce Clause and how it is moving power away from those that are governed without their consent to a central government in Washington. And what does Ms. Kagan complain about during the hearing? That she thinks the Supreme Court may be moving to reverse that, of which she adamantly disagrees. When asked about the Seminole case and the Lopez case, she worries that it moves us back to individual freedom and a more restrictive Commerce Clause. A Commerce Clause that says our rights are more important than those of the government, which goes back to the basis that she doesn't believe we have natural rights. The fundamental question of whether or not, as an individual, free in a country, can walk on to the Supreme Court and disavow unalienable rights and natural rights. It's a very dangerous concept. Because if you don't believe in natural rights, you don't worry about taking them from those that are governed. You don't worry about the Congress taking them from those of the governed. So we are about to move to a point where we're going to put somebody in a lifetime position on the U.S. Supreme Court who believes in foreign law, utilization to interpret the Supreme Court and the issues before it, who believes that precedent trumps original intent of our founders. In other words, the arrogance is we're much smarter than they were. Our wisdom is better, we're more modern, therefore things have changed, and therefore we have to ignore what they've said. That the Commerce Clause is boundless. Even if Congress passes stupid laws, they have the right to do it, and there's no obligation on the court to look at the Constitution and the documents behind it and what our founding fathers had to say about the authority and what they intended and meant as they wrote that clause into the Constitution. And then finally, one last point. She does not believe in the individual natural right that you have as a person to defend yourself. She wouldn't embrace that, which implies, very rightly so, that the Second Amendment, even though we now have precedent, is at risk under Elena Kagan as a Supreme Court justice. So summing up, we're going to put somebody on the court that I see will further the problems we have versus starting to re-embrace the principles that made this country great. Are we going to embrace what's gotten us into trouble? We're going to embrace the $13.34 trillion worth of debt growing at $1.4 trillion to $1.6 trillion a day that's stealing the opportunity in the future? We are. We're going to put her on there. And her wisdom and her vision is that very different from our founders, our Constitution, and our natural rights. This will be a huge mistake for this country if we want to solve the problems in front of us. And as I said, I don't expect anybody to change their vote on the basis of my viewpoint. And I will congratulate her for being more honest and open on her testimony than others would, because normally we wouldn't find out these things about judges. Mr. President, with a worried heart, I yield the floor.